Appearances.
Good afternoon, Your Honor. Kevin Beck, bar number 8371, on behalf of Shanna Soars, who is here.
Thank you.
Amanda Roberts, bar number 9294, on behalf of the defendant, Yokio Soars, who's present in the courtroom.
Okay. This is, I believe, your motion.
It is, Your Honor. So, you can sit. We were before the court in March of 2017. At that time, plaintiff was represented by Mr. Friedman, Ken Friedman, and you allowed her to give some testimony about her violations of the court's orders at that time. In response, after that happened, you actually found her in contempt of court and you issued a 25-day jail sentence that was suspended based upon her continued compliance with court orders. I believe that the court's intent was to garner her cooperation to avoid continual violations of my client's joint legal and physical custody rights. On that day, there were a multitude of things that happened, but relative to this motion, you ordered that we would work, Mr. Friedman and I, on a new holiday schedule. We would come up with some additional plans regarding custody and visitation. And unfortunately, promptly after that, when I notified counsel that his client had actually violated my client's joint legal custody rights as we stood in court that day, Mr. Friedman promptly withdrew from the case. In fact, he withdrew before the order was filed, and you pulled him back in to get him to work with me to finalize the order. That day, March 14th, the children were not in school, and Mom failed to notify my client at all that the children weren't in school. We learned about it after the fact, and on that day, you asked her specifically what she was going to do to change the tenor of the case to fix the continual violations, and she gave you her dog and pony show about what she was going to do, but didn't tell you the important things about what were going on, which were the fact that they weren't in school that day. She hadn't notified my client. She had the opportunity to do that day. After Mr. Friedman withdrew, my client communicated with her, and then I communicated with her regarding additional violations that were continuing to occur to the terms of the decree of divorce and subsequent orders issued by either you or Judge Potter. There are a multitude, and I know you've read it, so I won't go over every single one of them, but we had 14 as of the filing of the motion, and it's occurring on a regular and consistent basis. If you want me to, I can go over all 14. I acknowledge that there was one count of contempt, count number 3. Mr. Friedman was ordered by this court by agreement to complete a letter to Doral Academy St. Rose campus?
No,
Doral Academy,
Cactus.
one of the campuses that Cactus campus. And we asked, I can't tell you, no less than 10 times for a copy from Mom or Mr. Friedman for a copy of this letter that was supposed to be sent. It wasn't until last month after I filed this motion that I finally got him to be able to give me a copy of it, and I asked at least 10 times between myself and my staff. I also asked Mom for a direct copy. After we filed this motion, she continued to violate my client's parental timeshare and joint legal custody rights. I outlined them for the court in the ex parte request, and I outlined them for Mr. Beck in multiple correspondence. For example, Mom has most of the school days. Mom gets home from the children in their backpacks. School notices that do not get uploaded.
None of this is before the court. This isn't part of her motion.
It is. It's part of the filing with the court.
It's not.
You talked about, I don't remember
It's
school
in the reply
backpack.
as well.
No, it's...
I don't recall reading anything about school notices and homework and things like that.
It's in the reply that was filed. You want me to give you the page number?
I just read it last night. Did I gloss over something I shouldn't have? I usually just gloss over the statutes.
It was in the ex parte application for an
Hold
order
on.
shortening time.
Hold on.
It's a big folder.
For today is the motion to issue an order show cause,
The reply.
the return hearing, an opposition and counter motion, defendant's reply, and that's what, we're not here on an order shortening time motion because that was denied because I didn't issue this
Yeah, it's on
shortened
page
time.
9 of the reply. It starts on page 9.
The reply was filed
2 weeks ago.
19.
So it's
Page
all,
what?
Page 9, page 10.
Hold on.
We'd also have new issues being raised in the reply. I mean, issues with new concerns being raised in the reply.
Oh, there's enough stuff here that doesn't matter how much more she piles on in the reply.
Understood.
Go ahead, counsel.
Okay. I believe it's in there. I think it's at page 8 and 9. And I notified counsel of this. It's not a shock. For example, the school will send things home that do not get posted to Infinite Campus. Notices that they're having a parent-teacher conference. Mom is not sharing that information with my client, and therefore he's getting delayed in being able to schedule those kind of things. Report cards, progress reports, information is not being sent home. I notified Mr. Beck of it. After I sent notice, Mom did provide a couple things to my client, but he's being denied the opportunity to participate with the kids in certain events because Mom's purposely not giving him this information. So we outlined the contempt for you in the motion and in the reply. We also outlined for you a request for the modification of custody, as well as the prior order regarding holidays. They have this weird holiday schedule. You ordered us to work on a more traditional holiday schedule. I have tried to work it out with Mr. Friedman. My client tried to work it out with Mom. I've tried to work it out with Mr. Beck. We cannot come to an agreement on a standard holiday schedule. It baffles me, but we can't. So we've outlined for the court.
What's the sticking point? Because I can hit a button and you guys will have a standing holiday plan.
That's fine with us, Your Honor.
That's what they're using as the standard holiday schedule from Department M currently.
Not Department M.
I understand you're not. That's where the case was before. And that's what they've been using.
It actually is not what they're
That's
using.
the weird thing.
So, for example, my client only got a one-day block for Christmas vacation.
Give him my plan.
So what had to happen is my client had to save up his vacation time and ask for some of his vacation time during Christmas break. And so what Mom did, because he requested that, is Mom took the entire month of December except for 2 4-hour blocks so that he could exercise some holiday time with the kids. That is specifically what you told Mom not to do when you were before us last time. You were very clear about that point. So it's a continual and ongoing problem. It's a persistent issue. You told Mom at the last hearing when she was represented by Mr. Friedman that if we came back before her, number one, you were going to take her to the Clark County Detention Center. Number two, that you were going to set this matter, I believe, for trial on the request to modify custody because of the persistent and ongoing violations of Mom of my client's custodial timeshare and his joint legal custody rights. You also indicated as a result of Mom's continued behavior that it is causing harm to these children just based on the information that you had before you at the last hearing. And we come before you now almost 12 months later and it's continuing, and it's not one little thing. If it was one thing, we wouldn't be here. And when she violated on March 14th, we had the information within a week. And I didn't run back and file a motion and ask for you to put her in the Clark County Detention Center. I told my client to try to work with her. And there are emails after emails where my client is trying to do that, and I outlined those in the motion. So that's the request that we're making here today. The other thing that we're asking is for the court to modify the child support. Most important to us is not the contempt. Most important to us is the timeshare. Getting more time so that he can continue to work on his relationship with these boys, because the longer that Mom's behavior continues, the more it is a detriment to his ongoing relationship with these children. And that is the issue. So that's really what we're here for. We're asking the court to set it on an expedited trial setting to get us in as quickly as possible so that we can get this done and get this moving forward. One thing that I outlined in the reply, I don't know if the court will recall, was before Mr. Beck's time, they had a parenting coordinator in the case. It was Shan Weinset, and this court, it was by agreement, by stipulation that we would use Mr. Weinset. Since then, there's been an order that has come down from the Supreme Court or the Court of Appeals regarding parenting coordinators, and says that the court, do you want me to give you the citation?
No, you can tell me the nuts and bolts of it, though.
So essentially it says that appointing a parenting coordinator is not usurping your judicial role because they can still come before you. When Mr. Weinset was the prior parenting coordinator, your concern was that it was usurping the role of you by letting him work through these parenting coordination issues. In fact, at that time, and I pointed it out in the motion, there were things going on that he actually found where Mom was lying about things. He brought a report to the court about it. That is one of the ongoing issues, is without some kind of oversight, it's going to continue to go on, and it continues to go on as we stand here. So we're asking the court to address those issues. I'm asking the court to enforce the prior orders regarding contempt. If they're not enforced, I believe she'll continue to violate the court's orders. And I believe that without a modification of custody, my client's relationship with the children is going to continue to be interfered with by the mom.
Thank you, Your Honor. I appreciate that you commented that you have read the papers last night, and so I assume that you've read through all of our arguments as to why we do not believe that this is contempt. Basically, the allegations of contempt boil down to three different types of allegations here. First of all, she's saying that the boys are missing school. If you look through the stipulation and order as to what's required there, there's nothing that requires mom to reach out to dad and say the boys were not at school today before school begins. At some point, that's his contention, is that she didn't let me know before school started. She let me know that day that the boys didn't go to school, but she didn't let me know before school that they didn't go to school. And I think that where the other side is seeking to have her put in jail, it needs to be a clear violation of the order. I understand that I'm coming into the case now, and she's had other counsel before, but it's not as if mom is not letting dad know that the kids are sick or that they're not attending school. It's simply that it didn't happen on the time frame that he would like it to happen. The second thing is with regard to the change in school campuses. Again, at first blush, this looks like it's a violation, but if you really...
No, it's a violation.
Well, Your Honor...
No blushing.
I understand. What she did is she moved him from one campus to another.
Yeah.
And it's all within the Doral Academy.
No, don't care.
Dad had an issue.
I think they have Doral in Georgia. She can't move him there either.
I understand that, Your Honor. So immediately upon finding out that Dad wasn't happy with it, she offered to move him back and said, we'll take the kids, we'll move them back to the Cactus campus. Never did Dad say, okay, that's a fine resolution to this. Instead, they're saying, no, let's move them to these two inner city schools and have them attend schools where Dad teaches and the school right next to it. They're bad schools, Your Honor.
Does it matter that I went to one of those schools? Just thought I'd
It
ask.
doesn't. If you went to one of those schools, Your Honor, I grew up here in Vegas. I went to schools that are now bad schools. I went to Las Vegas High School. I went to John C. Fremont. I'm not sending my kids to Las Vegas High School. Well, it's different now, but I'm not sending them to the schools that I went to. Again, Dad has had no specific complaints with the Pebble campus, and nothing in his motion says that he has issues with the Pebble campus. We view this as being more opportunistic and saying, well, here's where mom has slipped up, and so let's try to take advantage of this and get her thrown in jail for 25 days. She's not working at the campus where the boys are attending school. She has volunteered there on occasion as they need help with stuff, but it's not on a regular basis. Mom is trying to get her life back together and back on track. Mom is in school. She's going to school for cosmetology. Any kind of disruption with that is certainly not in the boys' best interest, and having the boys see her go away to jail, that's not in their best interest. Dad's asking for a change in custody. We don't believe that he has presented sufficient facts to satisfy the standard under Ellis versus Carucci. He claims that there's been a change in the relationship with the boys. He doesn't tell us what that change has been, how his relationship with them has changed. They're more distant from him, any of those kinds of things. All of that is missing. Moreover, he states that it's because of mom failing to involve him in these decisions that this change has come around. And there really is no evidence or arguments to suggest that the purported lack of involving him in these decisions is causing a change in his relationship with the boys. Back with I neglected to mention the medical issues. That's another source where they're saying that she has been in contempt of the order. Mom regularly notifies Dad of all of the medical appointments. There was an issue where she gave him the incorrect time. The appointment started at 3:15 as opposed to 3:30 or something like that. It was a 15-minute gap. And Dad showed up late for the appointment. And so had he been there on time, there would have been no issue because the appointment hadn't started by then. In addition to not being able to show a substantial change in circumstances, they failed to show that this change would be in the best interest of the child, where modifying the custody would be in the best interest of the children. With regard to the change in his employment, he's gone from UPS, where he's worked for 15 years, and modified that and gone now to work for CCSD. He's trying to reduce his support in half. He hasn't really given us, aside from bare allegations that there's stress at work with UPS and he has to work some long hours, something that he's done for over a decade. He's now saying that keeps him from continuing to work there. And the needs of these boys have not changed. The cost of raising them has not gone down. And so we believe that there's some serious concerns there that bear some need for discovery as to why he made this change. Opposing counsel talked about Christmas and how December and how the times changed there. She failed to mention that it was her client who initially exercised all of his vacation time right around Thanksgiving. This year, the children got a week off for Thanksgiving, plus the 2 weekends on each side. My client had 17 hours of that week with the boys because of the way that he exercised his vacation time. And so I understand that there are some concerns with what happened in December, but he did that in November. He also took time in December so that he would be sure to have time with the boys near the Christmas break. I don't love the Department M holiday schedule, but that's what they've been living under, and that's what they've been trying to operate under. It does just give time from the 24th and 25th, and 25th and 26th for Christmas. That's all it talks about. And so that's what they've been going under. She's just been trying to live under the direction that she received from Judge Potter. I understand it's before you now, and if you're inclined to use a different holiday schedule.
I think it's more, the only thing that I don't have on my automatic one now is that the whole week of Thanksgiving, I think, is now a school holiday.
Yes.
And instead of just the 4 days, so I don't have that in there, but it'll suffice for now. So I'll get you in here before the next Thanksgiving.
Understood. And then the other things with regard to, the grades and such, they both have access to Infinite Campus. Previously, she's been told that she wasn't required to be his secretary and give him all of those kinds of things that he can access equally on his own. He has access to those through Infinite Campus, as she does. She has been adamant to take pictures of anything that comes in and send it over to Dad if it involves the children, if she gets notice of an event, and she's been sending those to Dad. We haven't had an opportunity to address the other issues that are in there, but Your Honor, we've gone through and addressed each of these allegations of contempt, and I don't think that any of them warrant imposing the sentence that was set forth before. That sentence, as I understood it, was towards her alienation behaviors, the allegations that she was alienating the boys from him, and none of these really go to that. And so I think that it would be a harsh and unfair result to cause her to go to jail for 25 days or impose that sentence. I understand. I think that Mom gets the message crystal clear that this is important. I'm certainly talking with her, and we've had communications that things are quite a bit different. And so I'm hopeful that the court will give her an opportunity to show that in the future, and that we can move on past that.
Thank you, Counsel.
I'll just be brief, Your Honor. As far as the missing school, if I understand what counsel's saying is he doesn't believe it's a direct violation because she's informing him after the fact. That's actually not going on. March 14th, my client didn't receive notice.
Well, March 14th was the hearing, right?
I understand.
So I'm
but I'll give you
really
a
not big
That's
on
fine. March 24th.
not dwelling on that one.
Okay. March 24th, she kept him out of school. My client received no notice. Not even after the fact, no notice. March 28th, she kept him out of school again. No notice to my client. Not even after the fact. March 29th, she kept him out of school again. No notice to my client. Do you want to know how he knows? He went down to the school, and if the court will recall, the The Doral program, because she previously worked there, is very difficult for him to get information. They're rude to him when he goes to the school. They're not cordial. He went down there and requested an attendance report, which is how we learned about all these dates. As far as, so that's what's going on regarding missing school. The change in school, there was never an offer by plaintiff to change them back to their prior school. That was never an offer made by counsel. That was never an offer made by mom. There is no offer that was made to switch their schools back. If they can point to an email, great, I'll take that, but we don't have one. We don't have any communication from her.
I absolutely sent that to her, Your Honor, and I will provide it.
In fact, as it relates to the school, Mom gave the court this story about the school and what happened, but we outlined for the court all of what happened. Mom actually had to apply for the new campus. This isn't a situation where they said, oh, we'd love the boys to attend. She actually had to apply. She actually, and I have all the dates. May I sit to go over the dates, Your Honor, real quick?
Go ahead.
Okay. So, we have the dates outlined in our original motion. So what happened for the court's edification is, let me find it. Sorry, it's long.
While you guys are doing that, looking at whatever you're looking at, do you have a work schedule, Mom? Where you work? You don't work? What's your beautician school schedule?
My schedule is Tuesday through Friday, 9 to 5. And I go to
For
school
how long?
until October.
And then?
And then I'm, as soon as I get my license, then I will be out.
So 9 to 5 till
Correct.
October of next year.
Yes. And I do go on Saturdays when the boys are with their father from 9 to 4.
Dad, what's your work schedule?
Monday through Friday, 7:10 to 2:30.
Okay, so what happened according to and it's the dates, what happened is that she applied for them to be enrolled. My client then took them to, she accepted enrollment. Then after she accepted enrollment, my client told her he was taking the boys to their open house at the school, the prior campus. At that time, knowing they weren't going there, she never said anything to him about the prior campus. He even showed her the Doral, they have that long list of required items you're to bring to school the first day. He showed her that list and asked about purchasing stuff. She never told him they were going to a different campus. And in fact, the first day of school took them to a different campus without notifying my client until after school had started that they weren't going to that campus. So Mom knew full well what was going on before she did this. It wasn't an offer to change campuses like she claims. She actually had to apply for the spots. Then counsel argued about the change in custody and that we didn't tell the court what the material change was. We did. We outlined it for the court. The court said at the hearing, the last hearing, that a substantial change in circumstance on March 14th, the court said, and I quote, if Mom continues along the lines of alienation and is not compliant with court orders, the court will revisit the issue of a change in custody. So the court put Mom on notice at that hearing that if she continued these behaviors, that it was likely the court would consider our request to change custody. Not only did it continue, as we outlined for the court, 14 or 17 issues of contempt, his relationship continued to deteriorate with the kids and continues to deteriorate. As an example, trunk or treat, he's available to attend. Counsel says, well, she shouldn't have to be a secretary. Well, the issue is the school doesn't always put notice on the Infinite campus of events going on. They send things home in the kids' backpacks in their folders. So what happens is mom holds on to that information. She doesn't share it, and then my client doesn't show up at these events, and the kids are like, what's going on? Why aren't you coming? Why aren't you supporting me? That's what happens. It happens at medical appointments. We outlined that for the court in the motion that we filed. She purposely tells him different times for the appointments. He shows up late, and then he looks like the bad guy because he showed up late. Or he doesn't show up. The child has appointments. She schedules him that day. He doesn't show up, so it looks like he doesn't want to be involved, and that's the message that's continually being sent to these children. And that is what the substantial change in circumstance is. I think it warrants the court setting an evidentiary hearing under Rooney. We outlined for the court all of the information regarding best interest factors. I went over them individually because of the new laws. Starts on page 20 of the motion. Mom says to you the kids are old enough to make a choice. In fact, she sends dad emails that say the kids should be able to choose where they want to go to school. I sat him down and asked him, you should do the same thing. You specifically admonished her on March 14th not to do that. So what she's saying to you is that they should have a input as to what their custodial timeshare is going to be. The level of alienated behaviors that have gone on warrants the court not considering the wishes of the child. Nobody has been nominated other than a parent. Then we talk about the level of conflict and the historic level of difficulty in co-parenting. We outlined for the court what's continually gone on. The lack of credibility with the parenting coordinator, the lack of credibility with the court. We talked about the continued level of conflict because of the refusal to co-parent, undermine, and interfere with his relationship with the children. We then talk about their ability to cooperate. I mean, it's all laid out there. It's not something where we didn't argue it as opposing counsel says. As far as the medical issues, what happens is to get him to not go, mom is scheduling him that day. She's taking him into like a walk-in appointment, and then she's telling him when she's at the walk-in appointment, although there's no emergency issue. Some of the instances she didn't even tell him. Child support we outlined for the court in detail. Thanksgiving, we outlined that in the reply. My client wanted to split the Thanksgiving holiday and the Christmas holiday. Mom's response was essentially no. I even tried to get counsel to agree to split those holidays, and that wouldn't happen. The bottom line is that it continues, and it's going to continue until this court sends a strong message. And I would have thought at the last hearing, when she had counsel and she told you all the things that she was going to do to change, it would have changed, but it didn't. And even as recently as after filing the motion, she was on notice of what was going on, and she continued to do it. And her counsel says, well, I talked to her, and I cautioned her, and I do this. None of that matters. If she won't do what you say, it's not going to matter what her attorney tells her to do either.
Your Honor, if I may, there's been a couple of new issues raised that I'd like to address.
Go ahead.
So, counsel is talking about the trunk or treat. There was no notice that went home to Shanna that she kept from him. Nothing went home to her regarding the trunk or treat. There were posters plastered all over the school. Mr. Soars picks up the children from school as well. He can see the notices regarding trunk or treat just as easily as she can. It's not as if she's hiding it. They make it sound as if she got some kind of notice that was delivered to her that she didn't pass on. She didn't. There's nowhere where she's saying, it's also on the school's website, but there's nowhere where she is saying or telling the boys that they can choose their custodial timeshare, as counsel has indicated here. What counsel has put forth is a bunch of their story, and what they are saying is facts, but those aren't true, Your Honor, and we should have an opportunity to show that those aren't true. We've set forth our story and our allegations here in our opposition brief, and we just don't think that it adds up to the type of contempt that they are talking about.
Okay. Thank you both. Here's what we're going to do. I'm going to grant the show cause hearing that you asked for. We'll set it in a minute, where you bring your proof and she brings her proof, and we decide what we're going to do about the 25 days.
Okay.
Dad, I'm going to change the custody temporarily until that hearing to father will have the children after school on Thursday till he takes them to school on Monday. Mother will have all other times. Visitation plan is going to be in place. This is a joint physical custody arrangement. Because it's joint physical custody, I need to adjust the child support. I'm taking both parties at their word as to what their incomes are right now. The income for mother would comport to a $464 a month child support. From dad, it would comport to $852. This is all without prejudice, pending the discovery you're going to do with regard to income and the perception that perhaps dad has dropped his income to lower his own financial circumstances just to not pay child support. Dad's child support would be $852. The net would be dad paying mom $388 a month for child support. Finally, and on a temporary measure until we get back to court, dad will be the primary legal custodian. He will make all legal decisions on behalf of the children with regard to their medical and and it's not funny. It's not something that we gloat about. I'm talking to someone in the audience. It is not good for these children, what's happening here. I regret even having to do it, but it's the law, and it's what I have to do. Let me just say something. All of you guys have an opinion about each other. Every single one of you do. And you liked them, and you don't like them, and then you liked them, and then you didn't like them, and this happened, and that happened. Life happens, and it's not pretty, and we don't die at 40 anymore. We live on to 100, and we have so many more opportunities to have ugly situations and not wonderful futures. That's just what life is right now. And because we're grown-ups and because we're adults and we can do what we want to do because the Constitution says we can do what we want to do, we can do what we want to do. The Constitution is silent on consequences. And the consequences are such that our children are carrying around the pain we place on them because as grown-ups we decide to have them and then we decide to break up. And then we decide to start other families. And then we decide that we want to do this and that and the other and we want to violate court orders or put people in jail. We do those things. And the kids, you're right, have no benefit from that unless the consequences fit the conduct and the conduct ceases. So I am ordering a show cause order where you'll have to prove your allegations, counsel. You'll be able to disprove them utilizing all of the orders that are currently in place. I'm making temporary changes until we can get to trial and see what's really in the best interest of these children. I don't know if the children have ever been interviewed by anyone ever in the court system. I'd like to have the children interviewed closer to the time of trial to see how things are going for them. And I'll give you an FMC and a time frame on that. If you guys had substantial funding, I'd get them their own attorney. Because sometimes we're so consumed in what we want and getting there that we forget why we want to be there. And those kids are ignored. So I'm going to make the wild assumption that we'll need a full day, counsels.
Yeah, sure.
Your Honor, can I address one issue? Through order.
Sure.
One of the reasons that the parties have structured the visitation the way that it has been in the past is so that the boys could attend church on Sundays. Could there be at least a block on Sunday where mom could come and take the boys to church?
I think that's too disruptive at this time. Do you go to church, sir?
No, ma'am.
I will have you take them to church, but I'm not giving mom a block.
Okay. So the order will be
His
that
obligation,
takes them to
that's an
church.
activity that they currently engage in.
It is.
They will continue to engage in that activity.
Can I ask one more question, because I know we're going to leave and it's going to be an issue. On the Thursdays and Mondays, if there's no school, what are the exchange times?
If there's no school on Monday, the exchange time would be 9 o'clock. If there's no school on a Thursday, in the afternoon, it would be 3. Wait, what time mother gets off work? 5, it'll be 6. Mom picks up right after, no, that's Dad's time.
Thursday starts Dad's time.
Okay, 3 o'clock.
Okay, and so the receiving parent picks up?
Receiving parent will pick up.
Unless it's an exchange at school, and then they'll just drop or pick up from school. The children are attending an LDS church in Mom's ward. If my client finds one in his ward, could they attend that one on Sunday?
I want them to attend with their mother, please.
Okay.
There's no sense in disrupting
That's fine.
those relationships.
That's fine.
You guys are going to hate this. If you guys are available on June 16th, I'll take you on June 16th. It's not a day I normally set trials.
That's fine, Your Honor.
This is for show cause, change custody, income infractions.
It's a Saturday?
Oh, I'm so sorry, the 15th. I apologize. Yeah, the 16th. We're going to come on Saturday.
You said it was not a
I'm
day you normally
punishing,
set trials.
I'm punishing everybody.
Kevin gets to bring the donuts and coffee.
I'm sorry, the 15th.
That's fine, Your Honor.
9 a.m. full day. Everybody's available?
Yes, Your Honor.
Yes,
That's
Your
good because my next available is September, gosh. Well, maybe not even then. I'm robbing Peter to pay Paul these days. October 8th is my next. So I try not to move cases if you can get this thing resolved between parties. And I'm going to make some guidance remarks.
You're hearing both issues on the 6th.
I'm hearing
15th,
everything.
Everything on the 15th.
Income, child support, change custody, legal custody, everything, and the show cause. So you're going to have to talk fast. No dallying on the examinations. Your discovery cutoff is going to be May 14th. I gave you a sheet of paper there, counsel, somewhere to write on. There you go. So you don't have to do a lot. I don't want you to get your hands cramped up. Discovery cutoff, May 14th. Pretrial memorandums are due by May 28th. The calendar call and bring your exhibits is June 7th at 2 p.m. Your show cause and trial will begin 6/15, 2018 at 9 a.m. I don't know what's really true about these boys and how they truly feel about anything. I know what I can read in the pleadings. I know what mothers profess, what dads profess, and that's all I know about your kids. I bet I know something that, without even meeting them, they don't want you guys to be here today. And they don't want you to be here in June. They want you guys to put your heads together and do what's in their best interest. Not what my family member wants or my family member thinks is cool. It's what's in their very best interest. Now, I know I had this talk with you guys before, and it kind of went in one ear and out the other from what I'm reading, and the reason I had to give the show cause is because I believe that somebody didn't really understand the totality of what I was the point I was trying to make last time. You guys get together with your attorneys, you work this out, and you don't go to trial. Your kids don't get interviewed and have to pick a parent. What a horrible, horrible thing to have to do. What a horrible thing to receive as a parent that you weren't picked. It's not their job. You guys chose to have children and chose to go on your merry way with your merry lives. They didn't have a say-so in any of it. But they're sure paying the pain for it right now. I don't want the children moved out of their current school circumstance unless you deem that it is appropriate. Then you'll talk to mom. You'll have the final say if you decide to move the children. If you move the children out of the current location, they will be in mother's school zone because mother has a majority of the school days. I think the best way to the heart of your boys, though, would not be to throw their mother in jail, if there is a problem there. Okay. Any other questions for this? Let me have the FMC. The return date would probably be this. I would say. Let's do it at calendar call. Yeah. Because I don't want to cost them more fees and stuff coming in.
That's fine, Ron.
The other option is to have me interview the children. If I interview the children, you both have to have your attorneys there. Your attorneys watch the interview. You never see the interview. The boys are able to freely speak to me as they wish. The counsel can't tell you what they said. I can tell the counsel what they're allowed to share and what my perceptions are as to what I would likely do on their benefit. You have that option. You can call my secretary if the two of you want to do that. You get to watch the interview, and you would also get to send me 3 questions to ask the boys on behalf of your clients. It's a stipulated agreement. It's not an order, so I'm not following the Rule 5 thing. It's an agreement that we do it this way. The video would be available for Supreme Court if they wanted to review it, but would not come into evidence.
Can I just put on?
If you'd like to do that, counsel, call Angie and she'll get you a date. I usually do them on Wednesday or Thursday afternoons after school's out.
The only issue, Your Honor, with the child interview, which is why we said in the reply we didn't want it, is that they're so aligned with mom and enmeshed with mom. That's the issue, but I think that comes out in the child.
I think that's what your client's spin is, and mother's client's spin is not that. And I think that being able to observe the children in a atmosphere of an interview may be beneficial to both counsel to be able to better guide their clients. Because you're going to believe your clients. I mean, you don't have a reason not to. And if they are not telling you the full truth, you can't fully help them. So I'm always willing to do the child interview myself, but only under that criteria. I don't want it to be viewed by either parent, because if the child does pick a parent, there's nothing more crushing And no matter how much you say, oh, it won't bother me, it bothers you. And it could work into the relationship. Yes, sir.
Approximately when would you want to know that decision by?
Whenever you guys want to, before trial. Yeah, you guys might want to do some discovery, see what you guys can work out without me talking to the child, which would be the very best. And once you decide it's truly going to go to trial, that there's no avenue of agreement that could be mitigated between the parties, if you want to do the child interview, just call Angie. I'm thinking if the trial is in June, sometime in April, so that gives everybody some time to chew on whatever it is I tell you I'm likely to do. Once I tell people what I'm likely to do, pretty much it helps to settle trials, and it also helps all these attorney fees to go away.
Okay.
Sorry, attorneys. All right. Mom, I'm sorry you're under so much stress. I really need you to buck up, be the mom, but you've got to be a co-parent. And it's not, how much can I get away with? It's full-throated, open, honest co-parenting. Okay?
So, Your Honor, he's currently in a period of vacation with the kids. His part of Christmas break. That's not going to change by this schedule. He'll be able to finish that.
No, we'll finish. When is your break over?
Supposed to
Sunday
be
at
Sunday,
5.
so he'd just return him to her Monday at 9 then. Or she'd pick him up Monday at 9?
Monday at 9 is fine.
That's fine. Okay, I just want to make clear.
No,
That was his.
Oh, when's her vacation start?
We still have vacations.
when's your vacation?
As soon as he's done.
Right after his ends.
For how long?
He goes until.
Until
The
they
8th?
go back to school.
We'll start this when school starts.
That's fine, Your Honor.
We'll start the new timeshare when school starts.
And then will you reserve on the retroactive request about child support for trial? The new one starts
The
January.
new award starts now.
Okay, that's
The trial is going to be the retroactive. That's without, now, somebody asked a good question and and then you asked me another one.
Sorry. We asked about the holiday.
Oh, no, it's something with through my head, and I just wanted to let you guys know. Anything happens to one of you, the other parent ends up being the parent. So much better for you to work with the children and the other parent and their relationship while you're alive to do so. Because if you pass, you're also leaving the children to face that alone also. So please put them first. I appreciate that there are family members here that support their loved ones. Please let them be the parents, because they are the parents. You guys were parents. You had that opportunity to do all those fun things and those sad things. And moral support is what you need, not do this or do that or helping to make things worse, please. Thank you all.
The offer, or the order and send it to Mr. Beck.
You're going to prepare, right?
Yes, I'll send it to Mr. Beck.
Did we already do that? Hold on. I got my
Yes,
prep
the
order.
schedule order. Yep. I'll wait for it.
Where is it? I'm going to sign the order to show cause now,
Okay.
and that'll be filed.
Okay.
I held it in the file. The hearing, I'm sorry, give me the date again, Madam Clerk.
6:15.
Counsel, Mr. Beck, I know you don't appear in front of me an awful lot, but I have what's called a preparation order, which says that this order has to be on my desk on January 23rd at 2 a.m., or I dismiss everything you have to co-sign on it, so she's going to prepare it promptly, get it over to you. If she doesn't make it right, then you have to do the order for the court to mediate between the two versions.
Okay.
Don't prepare your own version.
Okay.
Just say where hers is wrong and what was missing.
Just a letter outlining that?
No, it would be a motion. It's a motion for clarification. It's in the order, what to do. We'll give you that right now. If she fails to prepare the motion, you can do an order to show cause to hold her in contempt for not preparing the order.
I'll prepare it, I promise.
I know. Don't make plans to do this interview by the mediation center unless you, one, decide you are going to trial, and two, you don't want me to do it.
Okay.
I'm thinking April would be when you call them to let them know that that you have this order and get the date set up around April.
That's fine, Your Honor. Thank you very much.
Thank you, everyone, and good luck, everybody.